So we welcome everybody and we look forward to the knowledge that you're going to be imparting with us this morning.
Thank you so much, Michelle. No pressure, hey? Flippin'.
No pressure.
Good morning.
I know you're used to the Cape Town crowd that are part of this. So it's not that I'm excluding them. I'm just saying that that's the reach today.
Absolutely. Welcome, Leapfrog.
Oh, and Bloemfontein. So yeah, you've actually got them all around the country,
yes.
Huh?
It's a very national face that we've got this morning. Welcome to everybody. Thank you so much for joining us. You know, we really appreciated you taking your time out of your days to come and join us and listen to these talks that we do. My name is Hein Duisel. I'm a conveyancing attorney at STBB Attorneys. I'm further south than most of you, I suspect. I'm here in Somerset West in the beautiful Cape Town. You must please come and visit us, considering that the lockdown restrictions have been lifted, well, to a certain degree. You must just travel quickly before lockdown here at night. So, as Michelle said, what we're going to do today, we're obviously going to have a quick talk about defects in properties and the duty on the people, the sellers and the agents to disclose those defects. The other thing that I wanted to mention was that Michelle will probably be happy that it's not a very long talk today. It's actually a very quick talk, but I suppose you will all be happy to hear that. So to start off, what we're going to do is we're going to have a look and see and discuss the fact that honesty is the best policy when it comes to selling property and when it comes to disclosing defects in properties. And we'll go through the reasons, the not so obvious ones, etc. But we'll go through that. So let's start with a different type of defects. There are normally two types of defects in a property, and you will notice these defects are always mentioned in your footnotes clause as well. And we will see and discuss the footnotes clause to see why they are mentioned there. And there's a very good reason why they are mentioned in the footnotes clause. So the first defect that we get are patent defects. So these are defects that are visible, that you can see. So if you take your client walking through the house to view the property, or when you go and do a mandate and whatever, these are defects that you can actually see with your own eyes. So you can see that a window is cracked. You can see that there might be holes or screws in walls where picture frames were hung. You can see certain dampness in ceilings or dampness on the walls. You can see cracked floor tiles. You can feel that the doors, when you open or close the passage door or the bedroom doors, that they don't close so nicely. So those are all things that you can see, notice when you walk through the property and when you inspect the property. Then there are also latent defects. Now, these defects are defects that you cannot see when you walk through the property. You cannot see, for example, that the geyser is leaking in the roof. You can't see that there might be cracked tiles on the roof and there might be a roof leak. You won't be able to see whether the pool is leaking, because obviously the seller, when he sells the property, when he places it on the market, and if he's got a leak in the pool, I promise you, he will top that pool up 10 minutes before you've got your viewing at the property, so that people can't see that the level of the pool has dropped due to a leak or whatever. So these things are things that you cannot see. You cannot see them. Building plans as well. So when you go to view the property as a purchaser or the agent, you don't have insight into the building plans of that property. So if it turns out at a later stage that there are no building plans, that is a latent defect. That's a defect in the property that you won't see when you go and walk through the property. Also, title deed conditions. There might be restrictions in the title deed that doesn't allow the purchaser to build wooden or metal structures. I know that these days, these container houses are quite big and people build container houses. So it's important for the purchaser to ensure that there are no title deed conditions in the title deed that would prevent him from erecting iron or metal structure on that property, because that would affect his plans to build a container house on the property. So those things are defects that you won't notice when you walk through the property. So those are latent defects, things that you won't pick up just by walking through the property. You won't pick those defects up unless it is pointed out to you by the seller. Unless he tells you there's a leak in the roof, there's a leak in the pool, there's rising damp in winter time, you won't know about that. So those are latent defects in the property. So what does the law say? Well, there's a common law, the Footstoots Clause. There's also the Property Practitioners Act and mandatory disclosure. So we're going to see how the seller is protected with regards to these defects, and why we've got the Footstoots Clause, and what steps the agent as a property practitioner must take, and more importantly, the mandatory disclosure form. So with regards to footstoots, footstoots is a common law principle. And it actually means exactly what the word says, footstoots, with a shove of the foot. So when you sell something to somebody, you skop it now, you just shove it with your foot, you kick it to him, it's now his problem. He must take over the item. If there are any defects, it's his problem. He must take it. Subject to certain rules and regulations. So the Footstoots Clause is what you see is what you get. So if the purchaser accepts the terms in an agreement, they're accepting the product as is and renounces their right to claim any damages against the seller for any defects in that product that he has purchased from the seller. But what I also want to say is we will get back to the Footstoots Clause. There are certain rules and regulations relating to the latent and patent defects. Obviously, you will see in your Footstoots Clause. Your Footstoots Clause will state that the property is sold footstoots as is, in the condition as it stands, with all latent and patent defects. The seller cannot be held responsible for those defects in the property, and the purchaser accepts the property as is. So that rule is from common law. What the common law says is that if you sell something to somebody, obviously he can see the patent defects. If he's not happy with the item, he's not going to purchase the item. That's fine. The issue arises with latent defects, defects that he cannot see. And the common law says you as the seller, if you sell something to the purchaser, obviously you can't be held liable for the patent defects that he can see, but you can also not be held liable for the latent defects if you had no knowledge of those latent defects yourself. So that is where the common law comes in. Then, Footstoots versus compliance certificates, but we'll get back to the Footstoots Clause and the latent and patent defects. We'll get into more detail and we'll have a look at case law as well. So don't worry too much about that if you don't understand it right now. Then with regards to footstoots and compliance certificates, as you all know, in terms of the offer to purchase, the seller must provide an electrical compliance certificate or borer beetle certificate, electric fence certificate, in Cape Town, a plumbing certificate as well. So if there are any defects in that system that the seller was not aware of, well, the certificates will sort that issue out, because those professional electricians and plumbers, etc., and borer beetle inspection guys, pest control guys will come in, they will inspect the property, and then they will rectify those defects in the property that the seller or the purchaser might not know about, the latent defects. So that will be sorted out. Very often a question is asked as to whether those certificates can be deleted from the offer to purchase. It's a statutory condition, regulation, that those certificates must be in place. obviously your seller can say in the offer to purchase that he is aware that the electric fence is not in a working order and he is not prepared to pay for the rectification of the electric fence in order to issue a certificate. But then the purchaser will be obliged to get that certificate for the electric fence because it's a statutory condition that there must be a certificate in place. So the purchaser must accept that he will then be liable to go and sort out the certificate for the electric fence. So normally the compliance certificates will sort out those issues, but if they do agree otherwise, it's a statutory condition. If the seller doesn't want to provide it, it's a statutory condition that it must be in place. So then your purchaser must understand that he will have to get those certificates in place and he will have to pay for those certificates as well. Then we've got the Property Practitioners Act and Code of Conduct. So when we have a look at the Property Practitioners Act, the Property Practitioners Act says that a property practitioner must act with a reasonable care, skill, and diligence. It's a responsibility that the seller and purchaser does not suffer unreasonable damages due to a property practitioner not acting diligently with the skill and care that he should be acting. So the Property Practitioners Act places a code on the estate agent to say that estate agent, you as the agent, must also act with a degree of skill, care, and diligence to look after the interests of the seller and the purchaser if you are aware that there might be defects or damage in the property, and you must disclose that to the prospective purchaser. But we'll get into more detail with regards to that as well. There's a mandatory disclosure form. So in terms of section 67, subsection 1 of the Property Practitioners Act, the property practitioner may not accept a mandate from a seller or a landlord, if a landlord is letting out his property, unless the seller or the landlord has provided you as the agent with a fully completed and signed mandatory disclosure form. So obviously you all know those disclosure forms, you know the questions asked to the sellers or landlords when you sign up the mandate with them, setting out, asking them questions whether building plans are in place, whether there are any leaks, whether there are any roof damage, so you've got that questionnaire that you go through, and that is mandatory now. So in terms of section 67 subsection 1, you have to have that disclosure form. They have to complete it, they have to sign it, and you must provide a copy of that property condition report to the prospective purchaser. He must be fully aware of the condition of the property and what defects there are in the property. So the completed disclosure form must be signed by all the parties, and it will be attached to your offer to purchase. It will form part thereof. If the disclosure form was not completed, then it is presumed that there are absolutely no defects or deficiencies in the property whatsoever. So there is nothing to disclose to the prospective purchaser if it was not completed. The property practitioner who fails to comply may be held responsible to the affected customer. So if you didn't go through that property condition report, if you didn't complete it with your seller, if you didn't sign it, if you didn't provide it to the purchaser, and the purchaser then suffers damages as a result of those things not being done, then you as the property practitioner can be held liable. They can take you, that client, that purchaser can take you to the property practitioner's ombud and report you there and listen to the evidence, and then the purchaser might say, oh, but I suffered 20,000 rands worth of damages now as a result of the property practitioner not doing his or her job in completing or advising me. Then there might be a ruling to say that, okay, well, you must now take that 20,000 rand off your commission and pay it over to the purchaser that suffered damages as a result of your non-disclosure or non-completion of the mandatory disclosure form that you had to complete when you took the mandate. So in short, with regards to you as a property practitioner and with regards to safeguarding your purchaser and your seller with regards to defects in the property, you have to complete that disclosure form. You have to ask those questions to your seller with regards to what defects he is aware of, and he must disclose that. He will have to sign it, and the purchaser must sign it, that they accept the condition of the property. They've read through it. They understand that there are certain issues that the seller pointed out, and they accept it. And that condition report, which was signed by the seller and the purchaser, is then attached to the offer to purchase to show that all the parties had full knowledge of the defects in the property. It was duly disclosed to the purchaser, and the purchaser cannot now turn around and say that he didn't know about it. It goes a little bit further, but we'll get to that as well. Real life example, I will get back to this. I want to go through the notes quickly. There are a couple more slides, and then I want to get back to the real life example, and then we can use the example to close this discussion, to see what the courts found and what must be disclosed, what can't be disclosed, what can you hold the seller liable for if he didn't disclose it, what you can't. So that will just tie everything nicely together for us at the end of the talk. So homeowners insurance, you obviously know that with regards to property where there's a building or a structure, there would always be homeowners insurance over that building or structure. And very often the question is asked, okay, but what is covered, what is not covered? In terms of sectional title units, when you become the owner of that sectional title unit, you pay a levy to the managing agents or the body corporate. So every month, you as the new owner pay a levy to the body corporate. What does that levy entail? That levy is for obviously the general maintenance of the common property at the scheme. It would be for your stability fund. It would be, and the biggest part of that levy is for the homeowners insurance, because the body corporate will have a policy, one policy for all the units in that sectional title scheme. Each and every single owner cannot have his own insurance policy. Okay, Hein is now with Santam Insurance. Michelle is with First for Women. Pete is with whoever. Each and every owner in a sectional title unit cannot have his own insurance policy for obviously various reasons. If one of those owners don't pay their insurance policy, it affects the entire scheme. So that is why in a sectional title scheme, the body corporate organize the insurance policy over all of the units. And that is why you pay a levy. Big part of the levy to the body corporate or the managing agents is your portion of your insurance over that structure. So if anything happens with that structure, if it burns down, the body corporate doesn't have to go to 20 insurance companies in order to claim to rebuild these 60 flats, etc. And now one owner didn't pay his share, or he didn't pay his policy, so that insurance company is not going to pay. So that is why there is one insurance policy. Everyone pays their levy towards that one policy, and if anything happens to the property, that insurance company will pay out for the entire scheme. Even if there are 60 units, doesn't matter, they'll pay out and they'll sort that out. So each and every owner in a sectional title scheme will have homeowners insurance. It's with one insurance company. They don't have insurance. That insurance policy does not include, obviously, the internal household effects. Very often we get clients to say, okay, but I'm paying insurance, so that covers everything. I said, no, it doesn't cover you, your TV, your lounge suite, your laptops, your cell phones, your clothes, So you've got to organize your own insurance for those things. The homeowner's insurance is only for the structure or the building. So if there are geyser burstings, etc., or fires, then it will recover the structure, the building, the glass, the roof, not the personal effects inside. And another thing is if, for example, in a sectional title scheme, if your neighbor upstairs forgets to close his bath tap and the water streams over and now you've got leaks and damage to your roof in your property, the homeowner's insurance doesn't cover that. It just covers for the structure. So you as the owner here on the ground floor will have a claim for damages against the owner upstairs. You will have to pay in order for you to rectify your scheme. Unless there was a geyser burst in the common property, in the roof of the sectional scheme, and the water in the geyser in the common property rushed through to the units below, then the homeowner's insurance will cover that because it comes from a common property belonging to the body corporate as well. In conventional property, freehold land of 2695 Somerset West, where there's a structure, there'll always be insurance on that property if there is a bond on the property, because no bank will provide a bond to a purchaser unless there is homeowner's insurance on that structure or building. And again, the owner will have to insure his own TVs and lounge suites, etc. It's only over the building or the structure at the property. So, and that insurance will kick in when your purchaser becomes the owner of that property and his bond is registered. His insurance, property insurance, structural homeowners insurance will kick in from the day that the property is transferred into his name. So from the day that the bond registers, he will then have insurance over that property. If he doesn't take out a mortgage bond, so there's no one forcing him to take out homeowners insurance, he's paying cash for that property, he must remember that he must take out his own homeowner's insurance then with Santam or whoever he wants to take it out. He must organize his own homeowner's insurance over that property, because there won't just automatically be homeowner's insurance on his property when he becomes the owner. He must go and take out the policy. It's nice when you've got a bond because it's automatic. The bank's insurance will be there in place as from the date of when he becomes the owner of that property. Then the obligations of all parties, and then we'll get, I think, back to the case law that we're going to have a look at. So there's a duty on a seller to be honest and to disclose everything that he knows about. As you know, that's very often easier said than done, but okay. There is a legal duty on him to disclose. If he knows about a defect, he has to disclose it. The agent, as a service provider, must also obtain knowledge in respect of the product. So that is why you, as the agent, will have your property defect or property condition report that you will go through with the seller. That is your obligation. In order to, you may not get a mandate without that. So that is your duty, and that is what is expected from you as the property practitioner. So you, as a service provider, must obtain the knowledge that you can reasonably expect from that product that you are selling. So that is why you're asking those questions. You complete that questionnaire, the property condition report, so that you can pass that on to the purchaser, because there's a duty on you to pass that detail on to the purchaser so that he is fully aware of the condition of the item, the property that he's purchasing. If you don't disclose that to him or her, they can then hold you liable. And they can take you to Ombud and claim the damages from you to be deducted from your agent's commission, or sue you for damages that they've suffered because you didn't disclose that information that the seller disclosed to you. There's also a duty on a purchaser, and we'll have a look, especially in this case that we're going to have a look now. There's also a duty on the purchaser. The courts have said, Mr. Purchaser, very often there could be latent defects in this property that you cannot see. We understand that. For example, building plans, title deed conditions, etc., etc. There's a duty on you as purchaser to do the necessary and diligent inspection of this property as well before the offer to purchase is made. You cannot also merely rely on the information that the seller has provided to you, obviously via the agent. So the seller completed the condition report, provided to the estate agent, the agent provided it to the purchaser. So the courts have said, listen, Mr. Purchaser, you can't just take that as a given. There's a duty on you as well. If you have got your doubts of the condition of the property, because you need to remember, Mr. Purchaser, that sometimes the seller will not have any knowledge of the fact that there are no building plans, or that there might be title deed conditions that restrict you to build a wooden or iron building. He might not have even pool. The seller might actually not know that there's a crack in the pool because he's had a tenant staying there for the last 10 years. The tenant never reported the issue to him, so he had no knowledge thereof. So we understand that the seller completed the condition report, but you as the purchaser must understand he can only comply to the best of his knowledge. So if you've got your doubts, if you want to make sure that there are no roof leaks, pool leaks, title deed conditions, the duty is on you, Mr. Purchaser, also to go and inspect the building plans before you make the offer. You must be an informed purchaser, but the duty to be informed rests on you as well as purchaser. Because very often the seller might lie to the estate agent about the condition of the property. So the estate agent can only give the information that he or she received from the seller to you. So, you also need to go and inspect. If you want a professional property inspector that you do get, you can employ a property inspector to come into the property, have a look at the foundation, have a look at the plans. You're going to pay for it, Mr. Purchaser, but you also need to do your homework before you make an offer on a property. So there's a duty on a purchaser as well. And that is not going to be thank you, because now let's go and have a look at that case law. Okay. I'm going to make it a little bit easier for us. Haverside versus Hadrix. Funny surnames to pronounce. I don't like it. So what happened was Barbara Haverside was the seller of a property. Mornay Hadrix was the purchaser. So I'm just going to say Barbara and Mornay, just so that it's easier for us to. So Barbara, remember, was the seller. Mornay was the purchaser. Okay, so what happened was, in 2005, Mornay bought from Barbara a house. What Mornay then did was, as purchaser, remember, Mornay wanted, there was a double garage at the property, and Mornay wanted to build a flatlet on the double garage that was already there. Mornay then went to the municipality to get building plans so that he can amend the building plans, so that he can adjust it and supply or submit building plans for the flat that he wants to build on the double garage. When he got to the municipality and he got the file, because with the municipality there's a file with all the plans and letters and all those things. So when he got the file, he saw that there was a letter from the municipality to the owner in 1991. There was a letter from the municipality to say, Mr. Owner of Earth, whatever, we note that you are in the process of constructing a carport at your property. You must immediately cease with that construction because you have not submitted building plans for that carport with us. So Mornay saw that letter, the purchaser, he saw that letter. He obviously took transfer of the property already. So he took transfer, and then after transfer, he wanted to build on, etc. So he then saw that letter from the municipality, where the municipality told the owner that they must cease with the carport. There are no plans for the carport that they're busy erecting there. He obviously saw that there were no plans for the double garage. And then he sued Barbara, the seller, to say that, look, there was a latent defect in the property. Latent, I didn't know about it. There was no approved building plans for that double garage that you built. So it's a latent defect. So I'm going to hold you liable. You didn't disclose it to us, and you didn't tell us fraudulently. You kept that information away from us because you wanted to get a bigger selling price for your property. So Mornay then took Barbara to court on those terms and conditions. The court then, the magistrate's court, had a look at the facts. They asked Mornay, but Mornay, did you go to the municipality before you made the offer, did you go and have a look whether there are building plans? And he said, no, I didn't go and have a look. I just thought, I assumed that the building structures were in order. They also asked him whether he went to have a look at the title deed restrictions, maybe, as to the building lines, etc. He said, no, he didn't go to have a look at that. They then gave evidence that he then called his architect as well, and the engineer. They then gave evidence to say that, look, the architect said there are no building plans for the double garage. In fact, the double garage is built so badly that the foundations of the double garage is not even sufficient for the double garage. Never mind the flatlet that Morne wants to build on top of the double garage. So no, foundations are not in order even for the double garage. So that's not good enough. The pitch of the roof of the garage is not sufficient. And the walls of the garage, it's only a one brick or one layer. It should be a double layer wall, which it doesn't have. So the building is not only is unlawful because there are no plans for it, it's also structurally not sound. That whole building, that double garage, will have to be broken down. So evidence was led. It was going to cost about 100,000 rand to knock the purchase price. Just for interest sake, the selling price was about 900,000 rand in 2005, and these breaking down of the garage, rebuilding the garage, getting the plan sorted would have cost about 100,000 rand to get it as what it should have been. They then also, the magistrate then also called, obviously, Barbara as the seller to say, look, what happened here? She said, but look, I bought this property in 2005 for my mom. Well, in 1991. I bought this property in 1991 for my mom. I never stayed here. I only visit the property once a year. 1 December, when I came to visit them, I saw there that the carport that was there, they enclosed it. So they built walls and the garage door, and I just assumed that they obtained building plans. I didn't check up whether building plans were obtained or submitted to the municipality. I had nothing to do with the maintenance of the property. I had nothing to do with selling of the property. My mom wanted to sell the property, and I told her, well, sell it. I'll give you the mandate to sell the property and to proceed with the sale of the property. I'll give you the authority to get an agent involved, but I don't want anything to do with the property. I bought the property for you to stay. If you want to sell the property and go somewhere else, it's fine, but the property is not my problem. So even though all that evidence was led, the court said that, look, you as the seller, there's a duty on you to ensure that there are building plans for structures or buildings at the property. And because you didn't investigate whether your mom and the brother that did the building of the walls and closing the carport and the garage, you didn't go and investigate and ask the questions and go to the municipality. So, there's actually a duty on you as the owner to sort this out, to ensure that there are building plans for all the structures erected on your property. You didn't do that, but there was a duty on you to do that. So not disclosing that, you were negligent in not disclosing that to the purchasers. So the magistrate's court said, Barbara, you are liable. So you must pay to have this place knocked down, get building plans, and get it rebuilt to the way that it should be. So there's a judgment against you for 100,000 rands worth of damages that Morne suffered. Barbara said, no, that can't be right. So she then took the matter to the appeals court. So she appealed that condition in the High Court in Pietermaritzburg, and the court there in the appellate division said, look, let's have a look at the facts again. In terms of the footstoots clause, the footstoots clause is very clear. The common law is clear, and the contract also stated it, that the seller can be held liable, cannot be held liable for latent or patent defects in the property. The latent defects, the seller cannot be held liable if he had no knowledge of those defects. And if he didn't disclose that defect, if he had knowledge and he didn't disclose it because he wanted more, he fraudulently didn't say anything about it because he wanted more for his property, then the seller will be liable to the purchaser for the latent defect. Only if the seller had knowledge of the defect. But having knowledge is one thing, but secondly, didn't disclose it because you fraudulently wanted more money for the property, and you knew if you told the purchaser that there are no plans for that double garage, and in fact, it's not even according to the building regulations, you knew you'd have gotten less money for that property. So that is why you didn't tell the purchaser. So for a purchaser to hold the seller liable for latent defects, you have to show both those requirements. Seller had knowledge and he intentionally didn't disclose it because he fraudulently wanted more money for the property. So the court had a look at the case and the court said, but if we have a look at the evidence, it is clear that Barbara, the seller, purchased the property and what they saw was that Barbara actually purchased this property from somebody that worked at the municipality. Barbara was never told that there were no plans for the original carport that was built there. She didn't know that. She bought it from somebody at the municipality, and she also assumed that there are building plans. The same as Mornay assumed there were building plans. She also assumed that there were building plans. She never saw anything wrong or suspected anything. She never saw that letter that the municipality wrote actually to the lady that sold the property to Barbara. She never saw that. She had no knowledge thereof. Secondly, she never lived at the property. She once a year, normally over December, she would visit her mom at the property. Her mom resided there. She bought the property for her mom. So once a year she would visit there. And one December she did notice that the carport was now enclosed with a door, but she just, she had nothing to do with that property. She wasn't involved with the maintenance, upkeep, or anything like that. So she assumed that her mom did whatever she needed to do, got the plans, whatever, which obviously turned out not to be the case. But she did not have any knowledge of the fact that there were no building plans. So the court said, well, look, in terms of the common law, in terms of the footnotes clause, and in terms of the contract, you cannot hold a seller liable for any damage or latent defects in the property that she wasn't aware of. So in this case, Barbara had absolutely no knowledge that there were no approved building plans for the property. So she couldn't disclose that to Mornay, the purchaser. And the fact that she didn't disclose it because she didn't have knowledge doesn't show that she's got fraud on her side or that she wanted a bigger price for the property. In fact, when the court had a look, Barbara gave her mom that stayed there. Her mom told her that she wants to sell the property and move somewhere else. Barbara said, Mom, I bought this property for you. It's for you to decide. I give you the authority to sell the property, get a mandate, sell the property, just make sure that you get a good price. But, it's your property. It's got nothing to do with me. So you sell it. I'll give you the power of attorney. You do whatever you do. So Barbara, the court found, had absolutely no communication with the estate agent, with the purchaser, at all. Nothing. Not via phone, email, nothing. So the court, on the appeal, found, obviously, that Barbara had no knowledge and that she didn't withhold information from the purchaser because she wanted to get more money. That was not her intention at all. Her mom just decided to sell the property and the property was sold at the best price, and that was it. So that is the important thing that this court points out. And it's there to show the purchasers, Mr. Purchaser, despite the fact that the seller has completed the condition report of the property and provided that to the estate agent, who then provided it to you as the purchaser, you cannot take that as gospel. There's a duty on you as purchaser to do your own inspections, to go to the municipality, get copies of plans, because you as purchaser must also remember, the seller might not know that there are no plans. The seller might not know that there's a crack in the pool or that the roof is leaking, because the evidence might show that the seller never ever stayed in this property. So he never had knowledge of those defects in the property. So when the seller completed the condition report of the property that the agent took there to complete, the information that he provided is to the best of his knowledge. And if you, as the purchaser, has any doubt or you want to check up, then there's a duty on you, because if this matter goes to court and the court finds that this seller had no knowledge that there are no building plans, or that there's a crack in the pool, or that there's a crack in the roof, you as the purchaser cannot hold that seller liable for those damage, because he had no knowledge of those damage. You can only hold that seller liable if he knew that there was a defect in the plans or the pool or the roof, and if he withheld that information from you because he wanted a bigger or better price for his property. So,
Hi.
yes, Michelle.
There is a question from Sharon from Richards Bay, and she says, if an agent asks the seller if the plans are up to date and the seller says they don't know, is the seller then obliged to find out that information, or would it be the agent now that would have to do it?
I don't think the agent will have to do that. It is only the seller that can go. Even if you as the agent go to the municipality and you tell the municipality, please give me the plans for whatever, the municipality will say, sorry, we can't give it to you. It is only the owner that can come and collect those plans from us, unless the owner gave you a power of attorney authorizing you to go collect those plans, then you can go and get those plans. But yeah, so if the seller says, look, he doesn't know whether there are plans, and he's not prepared to pay the 200 Rand fee that the municipality charges for plans, then you must just ensure that you insert that in your condition report. State there, are there building plans, are there approved building plans for all structures on the property? Right in there, the seller doesn't know. He's got no knowledge thereof. He doesn't know whether there are completed building plans. The purchaser must go and obtain it if he requires it. The seller is not prepared, whatever. But as long as it's disclosed that he doesn't know, then the purchaser is informed. And then the purchaser can make a decision whether he wants to go and obtain the building plans or not. Obviously, it is a good idea, because you don't want anything to bite you again in the future. So I would suggest get building plans just to safeguard yourself, because the purchaser might turn around and say, but you as agent, you should have foreseen a little bit of an issue here. If the seller said he doesn't know, I didn't really read the disclosure form, and you should have made me aware of the fact that I need to go and get plans, etc. So if the seller doesn't know, put it in the disclosure form, absolutely, that the seller has no idea whether there are approved building plans for all the structures. And then it is a good idea to go and get copies, just to have a look and see. But that is the case in any event. So we have completed our Haverside or Barbara and Mornay case. We've dealt obviously with the latent and patent defects, the disclosure form that must be completed to the best of the knowledge of the seller, obviously, and that must be provided to the purchaser, because if it is not provided to the purchaser can turn around and hold you liable as a property practitioner to say that you didn't act with the due diligence and skill, and they're going to take you now to the ombudsman to go and sue for damages. So do all those lovely things. Are there any other questions other than Sharon's question? I think that is it. Thank you so much, guys. Thank you for listening to me this morning. Good luck with wherever you are. Hopefully, COVID stays away from you and your family, and you're healthy and safe. Thank you for listening to us. Thank you, Michelle, for giving us the opportunity to chat to you guys. We really appreciate it. Thank you so much. And if you've got any questions or queries, you'll know where to get hold of Lani and myself. Please email us or phone us, and we are always happy to assist and answer questions. Thanks a lot, guys.
Great, thanks, Hans. Sorry, I seem to have lost connectivity there.
No problem, Michelle. Thanks a lot.
Always out of the picture. But thanks. I think that was very informative. Just one question from my side, Hein.
Yes.
Obviously, we know building plans are becoming more and more of a issue or a bone of contention right now between sellers and buyers, and a lot of the banks are now obviously requesting to see approved plans and that. So, yeah, I kind of think that I think there is going to be more responsibility on the side of the agent to ask those very pertinent questions. Because you know it's a case of it's always the agent that's going to get the blame here.
Absolutely. But Michelle, just a quick, I'm not going to take your time. I know I went over my time, but just a quick, interesting. I'm doing a transfer right now of a property where in the condition report, thank heavens, the estate agent, it was duly completed that the garage at the property was converted into a flatlet. So all they did was they removed the obviously the sliding door, and they put in a patio door, and they screed the floors, and they put a ceiling in the roof. That's all they did. And FEB came back to say there are no plans for the amendment that was done to the garage. They will not give the final approval until such time as they've got municipal approved building plans for that addendum. Luckily, the agent in that scenario completed that disclosure form, which clearly stated that the original garage was converted. There are plans for the garage, but the conversion with regards to the patio door, sliding door, the screed floors, and the ceiling is not on building plans, and the seller will not take responsibility for that. So what happened was, obviously, the purchaser came back to say, hey, Mr. Seller, I need approved building plans because my bank requires it. I could then write back to the purchaser to say, sorry, it was disclosed to you. You knew that there were no building plans for the amendments to the garage. So if your bank requires it, the duty is now on you to supply it to your bank. So either you go and get the plans approved, or you go to another bank that doesn't require it. So I just saw this morning they're going with Absa Bank because Absa Bank don't require the plans. But yeah, banks do become more strict with regards to building plans, and those valuers that go out pick it up, and it's a condition that those building plans are there. So absolutely, building plans is a necessity, and one of these days there'll be new legislation to say that no transfer of a property can take place at the deeds office unless there's a certificate from the municipality confirming that all building renovations are in order and according to plan. So it's coming. So the sooner we get it's in the mode of getting the building plans, copies thereof, the better. Absolutely.
Right. Super. Well, thank you so much, Han. I did find that very interesting. I think agents, forget the difference between latent and patent defects. So it's always good to be reminded, and just what our responsibility is to our clients out there, and obviously always try to act with best practices at all possible.
Absolutely.
Thank you so much, Han.
Thank you,
much
Michelle.
Have a good one.
Oh, you too. Bye.
Bye.
Bye.